May I begin with a simple proposition? Arms export licensing is not merely foreign policy performed behind frosted glass. It is domestic administration with foreseeable extraterritorial consequences. Decisions taken in the defense ministries of states with an outward import and export policy on arms and ammunitions, or for any exporting nation, reorders risks for civilians who will never see the decision file, never address the decision maker, and never vote in the polity that has chosen to deal in arms with those who may injure them. The paper, therefore, before us is right to insist that the central deficit is methodological. Too often, the file cites international humanitarian law, human rights law, migration, and monitoring as if it was the recital of a reasoning. It is, therefore, unfortunately, not so. This paper's essential contribution is to recast fairness and export control as a matter of method, norm integration, evidentiary discipline, and structured reasoning. The treaty architecture already points to that direction. The Arms Trade Treaty is not drafted as a charter for diplomatic sentiment. It is drafted as a preventive instrument. Articles 2 to 4 define the scope, conventional arms, arms ammunitions, and parts and components. Article 6 imposes prohibition. Article 7 requires, before authorization, an assessment whether the items could be used to commit or facilitate serious violations of international humanitarian law or international human rights law, whether they would contribute or undermine peace, security, and whether the risk is overriding. Article 7.4 expressly addresses and adds the risk of serious acts in gender based violence or violence against women and children. Article 11 addresses this diversion. Article 13 addresses reporting. However, none of these invites the language of a retrospective shrug. It demands an ex ante judgment about risk, contribution, gravity, and control. That is the first point which must be added and held firmly in one's mind. Article 31 3c of the Vienna Convention on Law of Treaties requires the interpreter to take into account relevant rules of international law applicable in relations between the parties. In this field, that matters enormously because the ATT's critical terms do not interpret themselves. Serious violations must take content from somewhere. Facilitate must take content from somewhere. The obvious legal context is supplied by binding human rights and humanitarian norms. Common Article 3 of the Geneva Conventions, the additional protocol, especially Article 48, 51.4, and 57, ICCPR Articles 6, 7, and 9, CAT Articles 2 and 16, and the level of the general international law where Article 16 of the Articles of State Responsibility form themselves as the bouquet of laws applicable. Therefore, this paper is right to reject the loose moralism. Systemic integration is not sentiment, it is a legal method. That is, if I may say so, somewhere where many licensing regimes lose their footing. As I have said, the prefatory declaration of law is not, in this sense, operative. Yet one, as I suggested earlier, might rely on Article 31.3c seriously. The practical questions must become sharper. If the end user is an air force operating in the active theater of war, one may ask whether there is creditable evidence of indiscriminate attack methods, disproportionate strikes, or repeated failures to take feasible precaution under Additional Protocol 1, 48, 51, and 57. If the end user is an internal security agency, one may ask whether the record discloses torture, ill treatment, arbitrary detention, or lethal abuse, contrary to ICCPR Articles 6, 7, and 9, and CAT Articles 2 and 16. One is no longer dealing in abstraction. One is mapping law to item, end users, and context. The domestic public analog is equally plain. Lord Master, in R.S.'s Secretary of State for the Home Department, X.B. Doddy, stated that the governing principle, with his usual economy, fairness in context-specific purposes, is presumed that the statutory power will be exercised fairly, and fairness will require often that the person affected knows the gist of the case and he is there to answer. This is a well known discussion that appears in the report of this particular case. The point, therefore, is not to confide in the prisoner's tariffs. It is a constitutional habit of the mind. If the affected person cannot know the operative case, he cannot answer. And if the court cannot see the operative case, it cannot, unfortunately, review this. This argumented line of perspective is sharpened further in South Bucks District Council versus Porter number 2. In paragraph 36 of said judgment, Lord Brown put the matter before a sensible dispute understanding. Reasons must be intelligible and adequate. They must explain why the matter was decided as it was. They must disclose how principles and facts of law were resolved. They must address the main issues, not every point in the papers. That is very nearly a complete answer to the culture of opaque export licensing. The licensing authority need not write a monograph, but it must produce a record from where one can tell the license was granted contrary to indicators which were discounted and the mitigation was considered sufficient. The same public law discipline that appears in Munjaz at paragraph 21, where Lord Bingham explained that the guidance is not the same thing as statutory command, it is optional. The House treated that the code was a guidance that should carry the weight and be departed from only cogent reasons. The language is acutely relevant to export control. Voluntary guides, implementation documents, treaty body practice, and structured risks criteria are not binding on the Act. But once a decision maker invokes them, or once they form a part of the legal basis, the decision is therefore then taken. Departure without explanation is not expertise, it is the arbitrariness in a well cut suit. The most directly relevant authority, of course, is Campaign Against Arms Trade versus the Secretary of State for International Trade in 2019. In paragraph 57 of the Court of Appeals, the irrationality of the review is discussed as a deliberately high threshold, and quite obviously so. These are fields of expertise, intelligence, defense, diplomacy, and the predictive judgment. But high threshold is not no threshold. What matters is that the court must remain sure. It must remain sure, as it did in paragraphs 138 to 145, where the court held that the question whether there was a historic pattern of breaches of international humanitarian law by the Saudi led coalition was a question that had to be faced, and that the past violations were obviously treated to future risk in Criterion 2C, and that the irrational and unlawful to proceed without making that attempt. This was a pivotal point. The court did not substitute its own risk assessment. It requires the executive to confront the right question. The court's reasoning there is, in my view, entirely consistent with the proposals in the paper. One need not convert NGO reporting or UN fact finding into binding law, but one can lawfully treat such a material as atmospheric noise. In paragraphs 134 to 35 of CAT, recognizes that NGOs and the UN panel of experts are a major contributor to the recording and analysis of ground news. That is exactly the right balance. Public reporting is neither conclusive nor dispensable. It is evidence which must be confronted. In 2025, in Al-Haq versus Secretary of State for Business and Trade, has further refinement. In paragraphs 92 to 95, the Divisional Court expressly framed it to give effect to international obligations, and that the court may examine whether the policy, properly understood, does indeed do so without directly enforcing or incorporating treaty. This is orthodox public law. The source of obligation is the policy, the statutory criterion, and the decision maker's discretion. But at the same time, the judgment also shows the other edge of the blade. At paragraphs 184 to 187, the court declined to interfere because of the other facts. A careful and thorough process had to be undertaken. The conclusion reached was clear, and in that sensitive field, the report rationality threshold had not been crossed. That is, the proper equilibrium, strict on method, restrained on merits. One should not dismiss the constitutional caution that sits behind this. Al-Haq also rehearses through Freedom and Justice Party at paragraph 140 and KU in paragraph 145 that customary international law does not simply stroll into domestic law uninvited. It may shape common law only where consistent with domestic constitutional principles. That matters because export control is not an occasion for the court to become an international tribunal in disguise. It claims a narrower and stronger proposition. If the executive says it is applying criteria informed by international law, then the court may ask whether the executive is genuinely integrated, the relevant norms confronted and explained in reason. This brings me to the paper's most practical contribution, which is a licensing template. It is admirably simple. First, identify with precision that the state may use and rely on the operational capability it enables. Secondly, identify the end user, not as a flag on a map, but as a unit, service, agency, or proxy actor with actual compliance and history. Thirdly, record the context: armed conflict, detention environment, diversion risk, and accountability capacity. Fourthly, the list must indicate consulted treaty practices, UN material, credible fact finding, recipient state material, intelligence wherever important, necessary, and available. Fifthly, articulate the right pathway. How precisely does this item in the hands in this setting facilitates the serious violations that are feared? Sixthly, the state must see the relevant norms in light of Article 31 3C of the VTLT. Seventhly, it must set out migration, verification, monitoring, and suspension triggers accordingly. Eighthly, and finally, the state must look at the outcomes in light of Articles 6 and 7. This is not bureaucracy for the sake of itself. This is disciplined legality. The paper's hypotheticals make the point rather well. Aircraft spares are not harmless merely because they are called maintenance. If they sustain the sortie rates for an air force credibly accused of repeated unlawful strikes, they sit within a capability chain. Surveillance tools are not neutral merely because the export papers mention counterterrorism and warrants. If the end user is credibly implicated, in counterterrorism or terrorism for that matter, this warrants a deeper study and understanding. In both circumstances and instances, unverifiable migration and mitigation is no mitigation at all. It is therefore mere decoration. So where does this leave us? In my respectful submission, at a rather traditional conclusion, the law in this field does not chiefly fail for want of more grand principles. It fails when decision makers drift from old fashioned legal habits, identify the right norms, ask the right questions, examine the relevant evidence, distinguish facts from assurance, and give reasons to another lawyer, to another court, or the actual test. Judgments that I have illustrated in this regard are most useful and help lay down the principles further. If I may end where the paper begins, fairness at a distance is not an appeal to sentiment. It is a demand for method. The exporter need not control the world, but it must control its own reasoning. And if it cannot show in a disciplined and reviewable way why a transfer is lawful, and under Article 6 and 7 of the ATT, read with 31.3 of the VCLT, the informed rules of IHL and IHRL, then may answer this paper and proposition without any hesitation. It is refusal that I venture to suggest it is not radical. It is simply law behaving as law ought to behave. Those words, I thank the organizers for allowing me to share my thoughts and perspective, and I am truly at a loss for not being there with everyone. Thank you.